Well, we have a special guest here today for today's show, today's discussion. We have the person who has been most successful in evading any on-camera presence here at Kaplan Morrell. And that is Brandy.
I was in one.
Yeah, well, you were one where you were deemed essential, and then the rest of it was just like shadowy side views as you passed by. It was kind of like trying to see the Loch Ness Monster or the Yeti or Sasquatch or something. It was like a Brandy sighting, right? So Brandy is our senior paralegal here. Brandy has worked with me now a joyful 19 years.
Yeah, it'll be 19 years.
19 years in October. So Brandy basically lives and breathes workers' compensation. You have my condolences.
Yeah, it's been a long 18 years.
Yeah, that's a long.
Long.
Would you say tedious, like limbo-esque, or like, are we talking one of the circles of Dante's Hell,
No, not that bad.
Good. Well, today we're discussing 5 things that we see our clients think will affect the value of their workers' compensation claim and really don't. And last week,
Phone call.
We're getting a phone call. All right, are we good now? Okay, our seasoned and practiced camera operator has taken care of that technological glitch. So we'll put a link down below on the 5 things that people think don't affect their claim, which actually do. And this week we're doing the reverse, which is things that people think would affect it but don't. And maybe next week we'll do things that people think affect their case and they're right. Okay. So number one is who's at fault for the injury. Oftentimes clients, when we're initially discussing the case or even throughout the case, they get very fixated on how the employer was negligent, how, they shouldn't have had just me doing that. That's a job for 2 people. And the employer was trying to cut costs and they had me doing it by myself. And what do we tell them, Brittany?
It doesn't matter. If you were hurt at work, you can only go through workers' compensation. You can't sue your employer. You can't sue your coworkers. That's the unfortunate part.
And the administrative law judge can't award you any more or less because the employer was negligent. The judge can't award you less if you were negligent, if no one was negligent. There is one exception, and that is if you come to work and you're drunk, you're high, stoned, which I guess, is there a difference between high and stoned? Probably not. Okay, so, or if there's some sort of safety rule and you willfully violate it, then your compensation can be cut in half. But otherwise, if just someone's at fault, someone's negligent, doesn't affect your case at all.
No.
And so sometimes we have a hard time telling people, it's not that we don't care, it's not that we're not sympathetic, it's just I can't do anything with that. I can't take it to a judge and the judge go, oh, well, let's award an extra amount of compensation. It just doesn't happen. Number 2 is what happens if people get freaked out. Hey, my employer closed, they transferred operations, my boss just sold the company, etc. And we tell them,
Doesn't matter.
Doesn't matter as long as what happened. The only thing that's important is that your employer had workers' compensation insurance in effect on the date that you got injured. And if that's the case, then it doesn't matter what happens to your employer. They could be bought, they could be sold, they could just close the door and be done with business, and it wouldn't matter at all. The insurance company would still pay for your compensation. Item number 3. How long you've been working. Oftentimes we have clients who will say, I was at this job for 38 years, giving them the best time of my life, etc. And now I got injured. And we tell them,
It doesn't matter.
Doesn't matter. Not that we're
hard.
Or we don't care. Or not sympathetic. But
it really doesn't matter.
And so oftentimes what we tell clients is, look, it doesn't matter if you got injured in your first day on the job or your first decade, if it was your second day or your second year or your second decade, doesn't matter. Your workers' compensation benefits are determined basically the moment you get injured. The body part you injured, and there is nothing the judge can do to award more or less compensation based on the fact that you've been on the job a long time. Now, it can sometimes indirectly affect it, because oftentimes, you know, if we're trying to fight over some benefit and there's a element where the judge has to have a lot of sympathy for you, people who've been working longer at an employer tend to get a little more sympathy. And sometimes it's a red flag if you've been injured and it's your second day on the job, but in general, it just doesn't matter. Number 4, you lose your job, but you can still do other kinds of work. If you're, and then we're talking after MMI.
Yes.
After MMI. Now, if you lose your job before MMI, and we can show another video of what MMI means down in the links below, but after MMI, if you lose your job, but you can still do other kinds of work.
It's good that you can still go to work. A lot of people can't.
That's true.
But it doesn't matter.
It doesn't matter. And again, if you're our client, we're talking with you, we'll be a little bit more kinder when we say it doesn't matter. We'll be a little more sympathetic. We'll hold your hand and say,
give more direction on what to do.
Give more direction on what to do, etc. But once you're at MMI, if you can't go back to work, but you can still do other kinds of work, even if it's like minimum wage type of work you've never done before, unfortunately, you're not going to get any other compensation and workers' compensation for it. And that's a hard thing for people to swallow, because a lot of people who get injured seriously get lawyers like us, and a lot of times those serious injuries mean that they can't do the kinds of work, they can't go back to doing construction or trucking or some other kind of work that they've done.
Heavy labor jobs.
Heavy labor jobs, etc., that tend to pay more, and it's really difficult for us to say, we're sorry, but as long as you can go back to doing some kind of work, I can't get you anything more once you're at MMI for not being able to go back to your old job. Hard discussion.
That is hard.
That's the hardest.
I had that this morning with a client.
Yeah, a hard one. Last one, number 5, is once you're at MMI, you keep working, you find another job, or you switch employers, or you keep working with your same employer. Will that affect what you get in workers' compensation? And the answer is
no.
Nope. We're going to still get you the same amount of money, regardless of whether you're working, not working, collecting seashells on the shore. Doesn't matter, again, whether you keep working. So that's kind of actually a good thing about the system, which is we can tell clients, particularly once they've reached MMI, go out, look for work, get a job. Will not affect what we can do for you. You don't have to be on unemployment at that point, or still be employed, thinking that somehow you'll reduce the value of your compensation.
Some people are actually happier when they're able to go back to work, even if it's not the same job.
That's true. And then there's some people who just do the same job year after year after year. But
what's wrong with me?
And me, because that means I've been here at least 19 years too.
That is true.
So, anyway, those are the 5 things that people would think would affect their case, but don't. And as always, if you or anyone you know has been injured on the job in Colorado or with a Colorado employer even outside the state, please have them give us a call at 970-356-9898, because we'd love to help you. Thanks very much. Bye.